Well, good afternoon, because in Brazil it's morning, and I would like to greet all, and also I would like to thank you, to say my gratitude, my thanks to the International Internship University for this invitation to be here to talk about judicial activism, fundamental rights, and the Brazilian Supreme Court House decisions during COVID-19. Well, it's important to understand how the Brazilian Supreme Court, which is our highest court, legal court in Brazil, made decisions during the period of the COVID-19 in Brazil. Well, this is the building of the Supreme Court, which is located in Brasilia, which is in the central part of Brazil, South America. Well, to understand, it's important to say something about the Brazilian Supreme Federal Court. The Supreme Federal Court is the highest organ of the Brazilian judiciary, and it is primarily responsible for ensuring compliance with the Brazilian Federal Constitution as defined in the Article 102. For this reason, the Supreme Federal Court is known as the guardian of the Brazilian Federal Constitution, and also responsible for protecting the Constitution, having the last say on constitutional matters. Well, to understand better, the court, it consists of 11 justices appointed by the President of the Brazilian Republic after approval by the absolute majority voting of the Federal Senate. By the way, the Supreme Federal Court is at the top of the judiciary and integrates the institutional design of the Brazilian judiciary, the National Council of Justice, an organ that controls the administrative and financial performance of the courts, as well as the duties performed by judges. One of its main attributions is to judge the direct unconstitutionality act of a federal or state law or normative act. The Supreme Federal Court also judges the declaratory action for constitutionality of a federal law or normative act, claims of non-compliance with constitutional precepts, and extradition requests by foreign countries. In the criminal area, the Supreme Federal Court judges common criminal offenses committed by the President and Vice President of the Brazilian Republic, by members of the National Congress, by the Attorney General, by their own members, among others. The Supreme Federal Court also acts as the final court of decision for ordinary and extraordinary appeals. It judges as an ordinary appeal, habeas corpus, writ of mandamus, habeas data, and writ of injunction decided in a single instance by the superior courts. If the decision is denial and as extraordinary appeal, the case is decided in a single or final instance when the appealed decision contravenes a constitutional provision. Well, now I would like to begin to talk about some case laws. And here in this part, we are going to talk for you all in India, the topic about judicial activism, fundamental rights, and the Brazilian Supreme Court House decisions during COVID-19. Well, the first case law we call declaration of non-compliance with the fundamental precept. We call ADPF 709 from the Federal District in Brazil. The purpose of the ADPF 709 from a Federal District are the actions and or omissions of the public power related to the health measures adopted to combat the COVID-19 pandemic, regarding the protection of indigenous people and their fundamental rights, especially the dignity of the human person, the right to life, health, and indigenous peoples to live in accordance to their social organization. The applicants claim that there is an imminent risk of indigenous genocide and ethnic extermination. The Justice Luiz Roberto Barroso, in the decision of the declaration of non-compliance with the fundamental precept 709 from Federal District, presented guidelines from the United Nations High Commissioner for addressing the pandemic and the resolution number 1 from 2020 of the American, better saying, Inter-Commission on Human Rights on Pandemics and Human Rights in the Americas when it comes to indigenous people, giving force through the incorporation of soft law decisions. In the words of Justice Luiz Roberto Barroso, we can see that although these guidelines are not binding, the current situation of technical and scientific uncertainty regarding the appropriate measures to face a pandemic of unprecedented proportions, or on how to protect indigenous peoples, these guidelines constitute objective and international standards on the matter offered by organizations of recognized experience. Therefore, it must be taken into account. The judicial decision in provisional measure of Justice Barroso promotes an approach to the international guidelines on the protection of the human rights of indigenous peoples in the COVID-19 pandemic, seeking a dialogue between the courts with the premise of protection of human rights and fundamental rights. This dialogue consists of an influence and interpenetration of decisions of national and international jurisdictions using arguments from one court to another. It is necessary to advance in the interaction between the global, the regional, and the local, strengthening the dialogue between courts, opening the internal legal systems in the light of the emancipatory rationality of human and fundamental rights, allowing to rethink the scope of justice. The Brazilian Federal Constitution establishes for the indigenous the exclusive enjoyment of the wealth of the soil, rivers, and the lakes existing in the lands that they traditionally occupy, thus considering those that they inhabit permanently, those used for their productive activities, those essential for preservation of the environmental resources necessary for their well-being, and those necessary for their physical and cultural reproduction according to their uses, customs, and traditions. At the international level, the main legislation that establishes such rights is ILO Convention 169, which deals with the indigenous and the tribal peoples, the latter defined as those whose social, cultural, and economic conditions distinguish them from other sectors of the national community, and that they are governed totally or partially by their own customs and traditions or by special legislation. This convention, internalized by Brazil through Decree 5051 from 2004, that allows the empowerment and respect for the identity of traditional peoples. In the current Brazilian political scenario, that what is evident, after all, is that indigenous people are still exposed and vulnerable, and it is necessary to protect their rights that have been guaranteed for a long time. And in this case law, the Supreme Court House made their task in order to protect the indigenous people and assuring political, or better, policies, health policies, in order to avoid a genocide during the COVID-19 pandemic. The second study case that I'm going to bring for you all is about the federative autonomy in Brazil. We have municipalities, we have the states, and we have the federal union. Brazil is divided as an administrative country in 3 parts. I think it's very important to focus this idea. And now I am going to talk about this second study case about federative autonomy. Well, the Brazilian Supreme Federal Court reaffirms competence of states, as I said, municipalities to take measures against the COVID-19. The court ruled that the federal government cannot interfere in measures taken by their other identities with concurrent competence. And it's very interesting because in the beginning of the COVID-19 pandemic, the federal government did nothing about health policies to combat the COVID-19. So the states and the municipalities, the governors and the mayors, they took measures in advance of the federal government. And when they took those measures, the federal government said, no, you cannot take these measures because it's our competence. So it was necessary, the Supreme Court, to decide that the competence, the policies to combat the sanitary measures with the sanitary measures was divided into the 3 bodies of the Brazilian state. Well, in this way, these federation identities can determine quarantines, isolation, restriction of activities without, it's important, without the union, the federal government being able to interfere in the matter. The lawsuit in judgment questions provisional measure 926 on procedures for the acquisition of goods, service, and inputs. The legal decision court was hindered under the direct action of unconstitutionality that we call ADI 6341. In the action, the Democratic Labour Party asks for the declaration of unconstitutionality of provisional measure 926 edicted by President on 20 March of 2020, as it understands that the norm disrespects the constitutional precept of the autonomy of federative identities and was edicted with the political purpose of researching the governors. The Supreme Federal Court's justice also highlighted that the section of provisional measure 926, which reads that the President of the Republic will provide by decree on public services and essential activities will be interpreted in accordance with the Constitution to preserve the attributions of each sphere of government. Thus, the decrees of governors and the mayors that are more restrictive than the measures of the federal government are valid. For the Justice Marco Aurelio, it is the competence of the Union, states, and the municipalities to take care of public health, as it is the injunction granted by him, the redistribution of attributions made by the general attorney or by the act, as MP we call act, does not rule out the concurrent competence of the federative identities, nor taking of normative and administrative measures by the states, the federal district, and municipalities. The Justice Marco Aurelio emphasized that the context of COVID-19 is that of a public health emergency of international importance, and that quarantine and other measures were recommended by the health surveillance agencies. And it's interesting because during this time, the federal government didn't want the quarantine in Brazil, saying that it was very harmful for the economy. And I think the situations between Brazil and India was very similar. And we have casualties about many people died by COVID-19, and the vaccination came very later, and by judicial decisions, not by the wish of the federal government. Well, continuing, by this term, the Justice Alexandre de Moraes said that if there are excesses on the part of the states and the municipalities, because the states, the Brazilian states and the municipalities were very restrictive with the quarantine against the wish of the federal government, which wanted everything opened in order to preserve the economy. Well, it is because so far there is not a general coordination of the Union on the fight against the pandemic, such as with regard to social isolation. For him, the judgment does not refer to merely bureaucratic administrative issues, but to one of the foundations of the rule of law, federalism, and its distribution rules. and thus the contested norm itself values cooperation, prior articulation between the bodies of power. It does not mean that one can advance in the competence of the other, but that there is a coordination. It is regrettable that in the handling of this unprecedented crisis in Brazil, and of course in the world, even in essentially technical matters with uniform treatment internationally, and our political discrepancies between unities of the federation and a lack of cooperation. For the Justice Edson Fachin, the worst mistake in the formulation of public policies is the omission that I said before from the federal government, especially for the essential actions required by the Article 23 of the Federal Constitution. It is serious that under the guise of exclusive or private competence, the inactions of the federal government are rewarded, preventing states and municipalities within the scope of their respective competences from implementing essential public policies. The state guaranteeing fundamental rights is not only the union, but also the states and municipalities. For the Justice Gilmar Mendes, the president of the Brazilian Republic has powers even to dismiss his Minister of Health, but he does not have the power to eventually adopt a genocidal policy. This, the Constitution strictly forbids. If any decree were to put people's public health at risk, it would certainly need to be challenged. Well, I think this study case is very interesting for you have a better comprehension how the court, the Supreme Court House in Brazil, made an important role during the COVID-19 pandemic in Brazil. Well, continuing, we are going to have another study case that I would like to comment, to talk to you all. It's about the ADPF 672 that we call precautionary order, that still talks about the federative autonomy. It was a very important, it was very important because the legal decision about the competences from the federal union, the Brazilian states, and the municipalities was very important. And it took a long time for the court to make its decision. Well, still in this case, we are going to see that as we saw, the states and the federal district enjoy concurrent power, while municipalities enjoy supplementary power within their respective territories to adopt restrictive measures during the pandemic. Therefore, complying with federalism and its constitutional rules on distribution of powers implies respecting the decisions of governors and mayors regarding social distancing and quarantine, suspension of teaching and cultural activities, and trade restrictions. And these topics were everything that the federal union was against. Well, we are going to notice that the Federal Council of the Brazilian Bar Association filed a claim of non-compliance with fundamental precept that in Brazil we call ADPF, concerning the actions and omissions of the federal government had been taken to manage the emergency public health and economy policies due to the outbreak of the COVID-19 pandemic. The claimant reports that the law 13979/2020, it's an act, provides for a series of sanitary measures, such as to enforce the use of isolation, quarantine, and restriction on some outdoor gatherings of people. The law also authorizes simplified and streamlined procedures for contracting goods, inputs, and services to support the strengthening of the functioning of health system. In its petition, the claimant points out that the National Congress has also approved the union's request and acknowledged the state of public calamity resulting from the pandemic. The Brazilian Congress allowed budget spending notwithstanding the limits and the fiscal targets set by the Fiscal Responsibility Law or Act. Therefore, although the union has these instruments to react to the crisis, most of the federal government's decisions do not address the health emergency. According to the petitioner, the actions taken so far have affected the country's governance and endangered Brazilians' life. The petitioner emphasizes that several states and the municipalities have implemented measures to contain social agglomeration and reduce the number of people infected. The claimant states that cooperative federalism model adopted by the 1988 Federal Constitution is the ground of the constitutional, administrative, and political agreement entered into the states and the municipal governments. According to the Articles 23, second, and 24:12 of the Brazilian Constitution, the Union, the states, and the municipalities have the power to legislate concurrently on public health matters. It may seem very clear, these fundamental articles, but in fact, it was not very clear because the federal government thought that only the federal government have the way to legislate about public health matters. And it was needed to call the Supreme Court House to say the last word about this matter. Well, amid public calamity, the actions of states and municipalities become even more crucial because local and regional authorities are the ones able to make a diagnosis around the evolution of indicators and the service capacity for healthcare, including intensive care unit and ventilator equipment availability in each region. And about the intensive care unit and ventilator equipment, it was another problem because many were bought by the federal government, but they didn't arrive to the hospitals, and it caused a lot of casualties, a lot of death in Brazil. Well, continue, we are going to see that the petitioner adds that the Brazilian president of the Republic acts in such a way as to escalate conflicts with the governors and the mayors, who in turn rely on federal support to implement the necessary health policies. In fact, states and municipalities rely on federal resources, remittance, and other measures taken by the federal government to grant economic relief, as it has a greater financial and technical capacity to coordinate efforts to overcome the crisis. According to the petitioner, the Minister of Economy has minimized the economic effects of the crisis and took a long time to adopt, which, when taken, were proved to be insufficient. That was the trouble, the great trouble about this situation. The Federal Council of the Brazilian Bar Association points out that the following fundamental precepts have been violated: the right to health, the right to life and the federative principle as the president of the Republic acts to undermine and discredit measures adopted by other federative identities based on their respective constitutional powers, which are independent and harmonious with each other. Upon these matters, the petitioner requests a provisional measure to enjoin the President of the Republic from performing acts contrary to social isolation policies adopted by the states and the municipalities, and to order the immediate implementation of economic measures to support the most affected sectors by the crisis. The Justice Alexandre de Moraes found that notorious divergences of opinions among authorities of different levels have caused insecurity and justified fear throughout society. Thus, in a single judge decision to be submitted to the full Supreme Court, the justice partially granted the provisional measure to acknowledge and ensure the concurrent power of the states and the federal district. And that was very important at that time. The justice also recognized within their territories the supplementary competence of municipalities to adopt and maintain the restrictive measures allowed in quarantine, regardless of an overcoming federal act on the contrary. It was very interesting. While the states and the municipalities were very restrictive with social isolation, the federal government in Brazil was calling the people to stay at home and return to work as normal life. And it wasn't a normal life. Well, according to the justice, this decision does not eliminate the power of the union to establish restrictive measures throughout the country if it deems to be necessary. Because in the end, the federal government said, well, it's not up to me, it's up to the governors and to the mayors. It was very difficult. Well, obviously, the court may assess on a case-by-case basis the formal and material validity of each normative act issued by the states and the municipalities. Still, according to the Justice Alexandre de Moraes, it is legally possible to file this specific type of claim before the court, aiming at avoiding public authorities' actions that could jeopardize the fundamental precepts of the Republic, including the protection of health and the respect for the federalism and its rules of distribution of powers enshrined as unamendable clause by Brazilian federal constitution. The Brazilian constitution guarantees health as a right of all and a duty of the state that entails universal and equal access to health actions and services. Therefore, the justice decided that it was not possible to grant the claimant's request to replace the discretionary judgment of the executive branch. On the other hand, the severe outbreak of coronavirus pandemic, COVID-19, requires Brazilian authorities at all levels of government to implement public health concrete protections and to adopt all possible and technically sustainable measures to support the activities of the unified health system. Well, the justice emphasized the judiciary is not supposed to replace the president's judgment of convenience and opportunity when exercising his constitutional powers. However, the judiciary has a constitutional duty to verify the facts and the decision's logical coherence taken on each case. Thus, if there is no consistency, the measures are flawed due to violation of the constitutional order and the principle of prohibition on the arbitrariness of public authorities. After these considerations and in respect of federalism and its constitutional rules of distribution of competences, the justice stated that governors and the mayors must be respected in their decisions regarding the imposition of social distancing, quarantine, suspension of teaching and cultural activities, and trade restrictions, as we said before. Federal identities enjoy autonomy, which implies distribution of legislative, administrative, and tax powers. In relation to health and the public assistance, including organization of food supply, the justice pointed out that the Brazilian Constitution provides for common administrative competence among the Union, states, federal districts, and municipalities. Likewise, the federal constitution provides for concurrent power among the Union, the states, and the federal district to legislate on health protection and on defense. Concerning the municipalities, the Brazilian Constitution also allows supplementing federal and state legislation if there is local interest. The justice also highlighted the political administrative decentralization of the health system in Brazil, pursuant to which the services are performed in outlying regions and the financial burdens are distributed among the federative identities, including sanitary and epidemiological surveillance activities. In his conclusion, the Justice Alexandre de Moraes stated that the Union must not cancel decisions that the states, the federal district, or the municipal governments have adopted or will adopt within their territories and aiming to fight the pandemic. And I also would like to bring for you all a last study case. We call also the ADI 6387. It's a precautionary order which discuss the right to intimacy and the private life. It's very important because we had a great legal discussion about fundamental rights, which during the COVID-19 pandemic were not respected as the Brazilian Constitution demands as a state of rule of law. Well, going to my final explanations, we are going to see in this study case the practice of sharing data by telecommunications companies with the Brazilian Institute of Geography and Statistics Foundation for supporting offshore statistical production during the public health emergency due to coronavirus COVID-19 violates the right to intimacy and private life. And I'm going to point out how it happened. Well, in 5 direct actions of unconstitutionality jointly decided, the Federal Council of the Brazilian Bar Association and the political parties questioned the constitutionality of the Provisional Presidential Decree 954/2020. Such measure enabled telecommunication companies to share data with the Brazilian Institute of Geography and Statistics Foundation for supporting offshore statistic production during an emergency public health situation resulting from the coronavirus COVID-19. In short, the decree obliges fixed and mobile telephone companies to disclosure the list of names, telephone numbers and addresses of their consumers, both individuals and legal identities, to the Brazilian Institute of Geography and Statistics Foundation. For the petitioners, the decree violates the provisions of the Brazilian Federal Constitution that ensure the dignity of the human person, the inviolability of intimacy, of private life, of honor, and of one's reputation, besides the confidentiality of data. The Justice Rosa Weber granted the provisional measure and suspended the effectiveness of the Decree 954/2020. The Justice emphasized that the emergency scenario resulting from the health crisis or the need of specific data to formulate public policies to cope with it were not underestimated. However, their fight cannot legitimize the violation of fundamental guarantees foreseen in the Brazilian Constitution. According to the Justice, the conditions under which the use of digital personal data takes place by public or private authorities is one of the greatest contemporary challenges to the right to privacy. As per Justice Rosa Weber, the paragraph 1, article 2, is the only provision of the Decree 954/2020 addressing the purpose and the method to use the data. However, the provision states only that the data will be exclusively used by the Brazilian Institute of Geography and Statistics Foundation to produce official statistics aiming to conducting non-presential interviews for household surveys. The decree does not delimit the object of the statistics to be produced, nor the specific purpose, nor the amplitude. It also does not clarify the need to make the data available or how it would be used. The Justice pointed out that the decree did not demonstrate legitimate public interest to share personal data of telephone services users, considering the necessity, adequacy, and the proportionality of the measure. In addition, the executive branch had the responsibility to do so when issuing it. Thus, although the decree wording mentioned that the shared data would be confidential, the decree did not present a technical or administrative mechanism capable of protecting the personal data from unauthorized access, accidental leakage, or improper use, either in its transmission or in its processing. It merely delegates the procedure to share data to an act of the president of the Brazilian Institute of Geography and Statistics Foundation without offering sufficient protection to the relevant fundamental rights at stake. These situations would be aggravated by the fact that the general law on protection of personal data, it's 13709 from 2018 Act, was not yet in force. The law defines the criteria for the liability of agents for any damage that may occur because of the processing of personal data. On 7 May 2020, the full court house of Brazilian Federal Supreme Court, by a majority, affirmed the provisional measure to suspend the effectiveness of the provisional presidential decree 954/2020. Well, the court asserted that the right to privacy and its consequent rights to intimacy, honor, and image emanate from the recognition that the individual personality deserves to be protected in all its manifestations. In order to apply such rights, the Brazilian Federal Constitution provides in Article 512 the inviolability of the confidentiality of correspondence and telegraphic communications, data and telephone communications, except in the later case by a court order in the cases and in the manner established by law for the purposes of criminal investigation or criminal prosecution. Well, for the court, the decree 954/2020 does not meet the constitutional requirements regarding the effective protection of Brazilians' fundamental rights. The court also pointed out that the Institute of Geography and Statistics Foundation website reported a partnership with the Ministry of Health to implement a version of National Continuous Household Sample Survey focused on monitoring COVID-19. The search is focused by quantifying the spread of COVID-19 pandemic and its impacts on Brazilian labor market. Well, now I'm going to finish, and my last words would be that the Brazilian Federal Supreme Court concluded that the permission to use the data collected to produce official statistics within 30 days after the pandemic be over was excessive. In addition, Article 4th, single paragraph of the Decree 954/2020 was disproportionate when allowing the conservation of personal data by the public entity for a time that clearly exceeds what is strictly necessary to fulfill its stated purpose, which is to support statistical production from COVID-19. Well, I would like to thank you all for your very kind attention to listen to me. And I would like to remember one of the greatest man in the mankind, Mahatma Gandhi, that the future will depend on what we do in the present. And thank you very much. Here, you all have my addresses, my email, Instagram, and thank you. Thank you very much once again for your very kind attention. And I'm very pleased and honored to be here to speak to you all. Thank you so much.